Hey, it's me, Matt Esquire, the blues lawyer here, and I have with me the verdict sheet from the Gibson versus Dean case. Now, overnight I went through it and looked at it, and here's basically my take on this. Now, as you are aware, or may not be aware, Gibson back in 2019 had sued Dean for infringing on a lot of its IP, specifically the Flying V and the Explorer designs, but additionally there were claims for the SG design and for the ES design. There were also claims for using the trade names Hummingbird and Flying V, specifically obviously the Flying V with the Flying V design. It's not a total win for Gibson, no matter what you may have heard. Basically, what Gibson, was told is, yeah, they do own, at least in Texas, at least in possibly the Fifth Circuit, they own these designs. However, they do not get to immediately put Dean out of business, which is kind of what Dean was afraid of. There is a doctrine in law called Latches, and what that means is if someone's wronged you, you can't just sit around for ages and ages and ages and do nothing about it. You need to not unreasonably delay in seeking remedy from the courts. That's called Latches, and that is actually one of the issues that the jury had to decide on here, which is odd because it's usually a matter of law, which is a matter of law is something that the judge is going to decide. The Latches went to specifically the Flying V design and the Explorer design. The jury said, guys, Dean has been using this for decades now. I mean, I believe that the Fuzzy Z from the ZZ Top video was a Dean. That wasn't a real Explorer, if my memory serves. If it doesn't, please let me know in the comments. I will gladly welcome your comments or your corrections on this. Waiting 30, 40 years to do something about it, that is clearly what's called Latches. Gibson should not have waited nearly that long. Now, some people are saying this is a loss for Gibson. Some people are saying it's a win for Gibson. And what I'm telling you is the standard lawyer app answer, which is it depends. Gibson only was awarded $4,000 of damages, which that's kind of an FU to Gibson for this lawsuit. However, it still has this ruling here, which could be construed as being what's called prospective, going forward. So basically, Gibson, you don't get to claim damages for all that past infringement that you sat on your ass and did nothing about. However, Dean, you need to go and come up with some actual new designs of your own and stop infringing on Gibson's IP. Additionally, there was what's called a counterclaim. It's a reverse lawsuit, basically. Think of it as you punch someone, they punch you back. So Dean had countersued, saying that Gibson, by using litigation, was what's called tortious interference with contract. They're using, their bully power to interfere with Dean's business. And that pretty much went nowhere. That wasn't really at the center of this dispute. What was at the center of this dispute were really the Flying V design and the Explorer design. There were also claims for, the Dove wing headstock, as well as the ES and the SG body shapes. The SG body shape I can definitely see. However, I kind of have a quibble with the ES body shape. Had I been an attorney there, I would have said, well, this claim is too vague. It needs to be particularized. I would have, at the very least, objected to the jury question on the ES body shape. And the reason for that is that there is no real ES body shape per se. ES is an abbreviation. It's electric Spanish. That's where they came up with the designation. And it covers a variety of designs. The original ES didn't have a cutaway at all. It basically looked like an acoustic guitar with a P90 in the neck. So that was one of them. Then you have the cutaway, and then you have the double cutaway, which even that doesn't have one single design. There's the original design, and then there's what's known as the Mickey Mouse ear design, which was the update, which I believe is still used today. So to say, oh, well, all of the electric Spanish body shapes really are Gibsons, that I have a problem with. I don't think that Gibson really could say that. There's also an issue here because the way it works in the U.S. courts is there are divisions, basically, circuits. It's kind of like the divisions in baseball or football or hockey or basketball. There is there are 9 circuits, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now, this case was brought in Texas, which is where Dean Guitars, which is owned by Armadillo Distribution, that's where they're based. There had been an earlier lawsuit back in 2005 against Paul Reed Smith, and that was brought in Nashville, Tennessee. That's the 6th Circuit. And the reason this is important is this creates what's called a split in the circuits. The 6th Circuit case, the PRS case, there was very good legal reasoning in the final decision where the judge said, let's say you've got some guy who sees Slash playing a Les Paul in the video for November Rain. He thinks that's great. He's going to march on down to his local guitar store and say, I want that guitar. I want a Les Paul. Now, the store owner might present him with a PRS, but it's a guitar. You hold them. You can read, I would hope. And you would see immediately that this is not a Gibson Les Paul, that it is a PRS single cut. So to say that there is confusion, really, there really isn't. There's not significant confusion to the initial purchaser. And the only thing that really you can claim a trademark on is the headstock, because that's where you're going to look to find the name, the headstock. That was undoubtedly, and I haven't read the entire docket in the Dean case. The Dean case, the docket, I'm not kidding, was 498 items long, and the shortest of those items are 2-page orders, and the longest of those items are 100-page complaints. A, I don't have the time to read that overnight. I am not Superman. And B, I don't have the money to download that entire docket. So the 5th Circuit, that's a 5th Circuit case. That's a 6th Circuit case. The 5th Circuit, which is where Texas is, has never overtly adopted that ruling. So what this means is, number one, Gibson can and probably will appeal. They want their damages. They don't just want $4,000, which covers lunch for the lawyers. And Dean's definitely going to appeal on this. I would. At this point, basically, Dean's biggest seller is on the chopping block. There's a stay of exit. If they do appeal, they will probably have to post some kind of bond, possibly, to stay enforcement of this. But if I was Dean, yeah, I'd file an appeal. In fact, if I was Dean's lawyers, I would have already filed a notice of appeal, because that's like $50 and it protects your client's rights. Dean most likely will appeal, especially for the Flying V and the Z design, which are 2 of its biggest ones. Another thing that's curious and had been pointed out by Glenn Fricker was that in the newest signature design of the Gibson Flying V, evidently on the back, on the logo, Gibson is using someone else's design on a Flying V, on their Flying V. If you look at the headstock, it is not an actual Gibson Flying V. The Gibson Flying V headstock is very rounded, as you can see in the background, and that one is extremely pointy. So it's a bit of irony there, and possibly could form grounds to appeal or renew based on it being new evidence that, hey, Gibson is using other people's IP. This is a win for Gibson going forward if everything stays the same. Dean probably cannot sell its Flying V or its Explorer here in the United States. That doesn't mean you're not going to see them. This verdict really only goes to Dean selling new ones. So if you were to go on the used market, yeah, you can still buy a Flying V, a Dean Flying V, or a Dean Z Explorer, whatever they want to call them. It really, though, what it addresses is everything going forward. And that's the long and the short of this one. It is a victory. It's not a total victory. It is a slap in the face to Gibson and a slap on the wrist to Dean, although it's a very hard slap on the wrist and possibly one that chops off the hand. So whether or not Gibson wins this outright at the end, that's yet to be seen. This is probably going to be a few more years of appeals. If I were a betting man, which I'm not, I would say that honestly, Gibson's probably going to come out on top here, if for no other reason they got the pocketbook. Dean is a much smaller manufacturer. They operate, actually, believe it or not, out of Florida. The days of Dean are about 30 years gone. Kids don't walk in and say, hey, I want a Dean. I think when I was in my early 20s, I did contemplate getting a Dean, specifically a Dean Flying V. Some of my friends talked me out of it by basically talking smack about Dean, saying that their quality control isn't that good. Well, that's kind of ironic because I later on purchased a Gibson Flying V as part of the Faded series, and I bought that one new, and it turned out to have bad wiring in the neck pickup. So I sold it and took the money and bought a used Gibson Flying V. I don't buy new Gibsons. I refuse to because of the quality control. That is the backstory here. I guess we're going to see a lot more of Mark Agnesi's smirking mug saying play authentic, or Gibson will sue your ass. So thanks for tuning in. Click like, subscribe, leave comments. Let us know what you think. Less fiddling, more playing.